My dear students, a very good afternoon. Today I am going to talk about powers and functions of National Human Rights Commission. The National Human Rights Commission is an expression of India's concern for the protection and promotion of human rights. It is a unique expert body which is created under the Protection of Human Rights Act 1993 for examining and investigating the complaints relating to violations of human rights, as also the negligence on the part of any public servant in preventing such violations. The main function of the National Human Rights Institution is to promote and protect human rights in its widest perspective. It is important to note that the Paris Principle laid down the minimum standard to be observed in setting up any national human rights institutions, even though no single model is prescribed. The Paris Principle affirms that national institutions are to be vested with competence to promote and protect human rights and given as broad mandate as possible, which must be set forth clearly in a constitutional and legislative text. The National Human Rights Commission has been discharging its role as a catalyst to improve the quality of governance, which helps in greater respect for human rights. In short, the National Human Rights Commission of India is seen as institutions which has proved that if properly constituted, such an institution is greatly efficacious in enabling the state to discharge its obligation under the United Nations Charter and the National Democratic Constitution of protecting human rights. Functions and the powers of National Human Rights Commission. The effectiveness and the impact of the Commission will depend upon the range of functions it is required to perform, the powers conferred upon it to accomplish the job, and the ultimate fate of its recommendations. Apart from its function of adjudicating complaints regarding human rights violations, it acts as an overseer of the human rights situations in the country with the help of its suo motu initiations. The functions that are to be discharged by the commissions are: the first one is inquiry, suo motu, or on a petition presented to it by a victim or any person on his behalf, or on a direction or order of any court into complaint of. The first one, violations of human rights or abatement thereof, or the second one, negligence in the prevention of such violations by a public servant. Next function is intervene in any proceedings involving any allegations of violations of human rights pending before a court with the approval of such court. Next function is about visit, notwithstanding anything contained in any other law for the time being enforced, any jail or any institutions under the control of the state government where persons are detained or lodged for purposes of treatment, reformation or protection, for the study of the living conditions of the inmates thereof, and make recommendations thereon to the government. The next function is review the safeguard provided by or under the Constitution or any law for the time being enforced for the protection of human rights and the recommended measures for their effective implementations. The next function is review the factors including act of terrorism that inhibit the enjoyment of human rights and recommended appropriate remedial measure. Besides these functions, the National Human Rights Commission also study treaties and other international instruments on human rights and make recommendations for their effective implementations. Not only that, it also undertake and promote research in the field of human rights, spread human rights literacy among various sections of society, and promote awareness of the safeguard available for the protection of this right through publication, the media, seminar, and other available means. Encourage the effort of non-governmental organizations and institutions working in the field of human rights, such other functions as it may consider necessary for the promotion of human rights. I would like to talk about the powers relating to inquiries. The Commission is vested with the wide-ranging powers relating to inquiries and investigation under the Act. While inquiring into complaints under the Act, the Commission could exercise all the powers of a civil court trying a suit under the Code of Civil Procedure 1908 and in particular in respect of the following. The first one is summoning and enforcing the attendance of witness and examining them an oath. Second one is discovery and production of any document. The third one is receiving evidence on affidavit. And the fourth one is requisitioning any public record or copy thereof from any court or office. Next one is issuing commission for the examination of witness or document. And the last one is any other matter which may be prescribed. After this, I would like to talk about the inquiry into complaints. The Commission, while inquiring into complaints of violations of human rights, may call for information or report from the central government or any state government or any other authority or organization subordinate thereto, within such time as may be specified by it. If the information or report is not received within the time stipulated by the Commission, it may proceed to inquiry into the complaint on its own. On the other hand, if on receipt of information or report, the Commission is satisfied that no further inquiry is required, or that the required action has been initiated or taken by the concerned government or authority, it may proceed with the complaint and inform the complainant accordingly. Next is about the steps of the inquiry, how the National Human Rights Commission is taking steps of the inquiry. The commissions may take any of the following steps upon completion of the inquiry. The first one is where the inquiry discloses to the Commission an act of violations of human rights or negligence in the prevention of violations of human rights by a public servant, it may recommend to the concerned government or authority the initiation of proceedings for prosecutions or such other actions as the Commission may deem fit. Second one is approach the Supreme Court or the High Court concerned for such direction, order or writs as that court may deem necessary. Third one is recommend to the concerned government or authority for the grant of such immediate interim relief to the victim or the members of his family as the Commission may consider necessary. Fourth one is subject to the provision of Clause 5 of Section 18, provided a copy of the inquiry report to the petitioner or his representative. Fifth one is send a copy of his inquiry report together with its recommendation to the concerned government or authority, and the concerned government or the authority shall, within a period of a month or such further time as the Commission may allow, forward its comments on the report, including the action taken or proposed to be taken thereon to the Commission. And the last one is make public its inquiry report together with the comments of the concerned government or authority, if any, and the action taken or proposed to be taken by the concerned government or authority on its recommendations. After this, I would like to talk about the procedure with respect to armed forces. The term armed forces for purposes of the Act means naval, military and air forces, includes any other armed forces of the Union. The Act envisages the procedure in respect to armed forces which is at variance with the procedure set out for complaints of violations of human rights by any other public servant. The Commission shall, notwithstanding other procedure of the Act, adopt the procedure while dealing with complaints of violations of the human rights by members of the armed forces. It may either on its own motion or on receipt of a petition seek a report from the central government, and after the receipt of the report it may either not proceed with the complaint or, as the case may be, make its recommendation to that government. The central government shall inform the Commission of the action taken on the recommendation within 3 months or such further time as the Commission may allow. The Commission shall make public its report together with its recommendation made to the central government and the action taken by that government on such recommendation. The Commission shall provide a copy of the report published under subsection 3 of section 19 to the petitioner or his representative. As per the Act, the National Human Rights Commission is primarily entrusted with the responsibility of inquiring into complaints against the gross violations of human rights The status of the Commission is strengthened by the definition, powers, function and procedure that it follows. It is also incumbent upon the Commission to submit an annual report and also a special report to the central government and the state government concerned. The said government shall have to present the report along with a memorandum of action or acceptance before its House of Parliament and also before the House of the State Legislature. The Commission is authorized to utilize the services of any officer or investigating agency of the central or the state government for the purpose of conducting an investigation pertaining to the inquiry. It is also noted that the functions are enumerated in Section 12, which encompasses a wide area to enable the Commission not only to inquire into the violations or negligence in prevention of violations of human rights, but also to promote the human rights culture and perform any function necessary for the promotion of human rights. Next is procedures and regulations of the Commission. In order to discharge the aforesaid function of the Commission, certain procedures and regulations are followed by it. The Commission convenes its meeting at the discretion of the chairman and also regulate its own procedure. In exercise of the powers conferred by the subsection 2 of Section 10 of the Protection of Human Rights Act 1993, the National Human Rights Commission makes the National Human Rights Commission Regulation 1994. For proper functioning of the Commission and as amended, the National Human Rights Procedure Amendment Regulation 1997 with effect from the first day of April 1997. This regulation have divided 3 chapters and they compose of 48 regulations. Regulation 8 clearly mentions the procedure for complaining, that the complaints may be made to the Commission in English or Hindi. However, the Commission may entertain complaints in any other language included in the I schedule of the Constitutions. No fee shall be chargeable on its complaint. The complaint shall disclose a complete picture of the matter leading to the complaint. The Commission may seek further information, affidavit as may be considered necessary. In this regard, the nature of complaint which are not ordinarily entertainable are also provided in Regulation 9 and are as illegible, vague, anonymous or pseudo-anonymous, trivial or frivolous, bar under Section 36 Clause 1 of the Act, bar under Section 36 Clause 2 of the Act. Allegation is not against any public servant. The issue raised related to civil dispute such as property right, contractual obligation, and the issue raised related to service matter. The issue raised related to labor, industrial dispute. Allegation do not make any specific violations of human rights. Matter is sub judice before a court or tribunal. Matter is covered by a judicial verdict decision of the Commission, where it is only a copy of the complaint addressed to some other authority. And the last one is the matter is outside the purview of the Commission on any other ground. Besides, Regulation 25 provides certain conditions of summoning, that whatever the Commission directs to summon. First one is the complainant or any other person on his behalf to afford him a personal hearing. Second one is any other person who in the opinion of the Commission should be heard for appropriate disposal of the matter before it. Third one, any person to cause production of record required by the Commission. The fourth one is any person to be examined as witness. Fifth one, any person whose conduct is inquired into by it. Or sixth one is any person whose reputation in the opinion of the Commission is likely to be prejudicially affected. Regulation 26 also provides whenever the Commission order investigation to be undertaken by its investigation division or by any other investigating agency of the central or state government as provided in Section 14 of the Protection of Human Rights Act 1993. A copy of such order along with copies of the papers relevant thereto shall be furnished forthwith to such division or agency calling upon it to conduct the investigation and submit its report within the time specified in the order, and if no time is specified, within 2 weeks from the date of the order. If no such report is received within the time given, the matter shall be placed before the Commission makes any recommendation. The setting of National Human Rights Commission under the Protection of Human Rights Act 1993 is an important development in the quest for human rights in India. The extraordinary range of the function and the scope of power assigned to the Commission under the Act, it is evident that the Commission must act and must be seen to act at all times with autonomy and transparency. In fact, the creation of National Human Rights Commission can be an important mechanism to strengthen human rights protection in India.